Okay, everybody, we're going to stay on track here with our next presentation on federal bid protests. This is Frank Murray, my partner from our Washington, D.C. office. He is the bid protest guru. He also has some articles over on that table, so I welcome Frank to the podium.
Thank you, and glad everyone could be here. This presentation is going to focus a little bit more on sort of practice tips and some things to sort of keep in mind as you're preparing a proposal even before, hopefully to try to avoid a protest. In terms of some of the very specific procedural issues and background on protest, those are covered in more depth in the practical law articles. So again, going to try to focus on things to do to, avoid the pitfalls, avoid the surefire ways to lose a protest, some pointers on how to protest and how to write a proposal in a way that hopefully makes it a protest unnecessary, or if you win the award, a protest against the award would be unsuccessful. And then I'll close with a practical example of a protest that we handled several years ago, which I think is a really good example of one of the ways that the protest process can be used and probably is perhaps underutilized. People sort of naturally think of protests as a situation involving an award, that there's been an award made, you didn't win, and that's when the protest really comes into play. But this example sort of shows that you can proactively, if there's an issue with a solicitation, try to address it prior to award, prior to proposals, and try to make sure that you avoid an issue that lets you compete in a better fashion. And it's a good success story of a contractor who took that proactive approach and ended up winning a contract because of it. So in terms of a bid protest, there's several reasons you might want to file a bid protest. Certainly the predicate typically is that you think the agency has done something wrong. They violated the terms of the solicitation. They've evaluated you in a way that they didn't say they would. Or they've violated some regulation or statute. And if you think you're next in line for award, it's another chance really to sort of further your marketing effort. Maybe they misevaluated you, they didn't give you credit for a strength in your proposal that they just didn't perceive, and you can try to explain to them, look, if you'd really seen that we had this benefit, you would have seen that we were the better value. So there is a sort of a second chance marketing aspect to it to try to educate the agency on why you should have been seen as the better value. When you're the incumbent, there's also a benefit to a protest that if you have a basis to protest and you do it in a timely fashion to stay the follow-on contract, that typically you're held in place under a bridge contract while the protest is pending. So with a GAO protest, there's a 100-day deadline for them to make a decision, so you can generally get another 3, maybe 4 months of work out of it, even if the protest is unsuccessful. There's an incentive there as the incumbent to try to protest if you can, have a basis to do so. And then finally, one of the benefits if you file a GAO is that if they do rule in your favor on the protest, or if the agency doesn't take corrective action until after the agency report has been filed, well into the protest process, you do have a right to ask for, and GAO will give you sometimes your attorney's fees in filing the protest. And if you're a small business, it's dollar for dollar what you paid, as long as it's reasonable. And then if you're a large business, there's a statutory cap, so it's not quite dollar for dollar typically, but you do get some reimbursement of that. In terms of who can file a bid protest, you have to be an interested party, and so that's typically if an actual or prospective offeror whose economic interest is affected by the issue. And so you need to generally show one area where you are found not to be an interested party that you can have a protest thrown out is if you're not going to be next in line for award, even if all the issues you complain about were true. So a good example of that is in a lowest price technically acceptable proposal where Acme company wins the award, they're lower priced than you, and you think they're not acceptable, and so you file some sort of challenge saying Acme shouldn't have been found acceptable, they don't do this right, they're not acceptable. But you're fifth lowest price, so there's 4 other companies or 3 other companies between you and them. That's one where GAO would say, look, even if you're right, Acme shouldn't have been awarded, there's 3 other people that you haven't attacked. So that would be one where you might end up getting thrown out because you're not in line for award, even if you win your protest. Another area where this interested party concept comes up a lot is when you're a subcontractor, and you may be a subcontractor, and there's a provision in the contract or a prospective subcontractor, and there's a provision in the contract that affects directly your aspects of the work, and you want to protest it because, hey, this is too restrictive. If they make it a little bit more, less restrictive, a little bit more open to competition, I could compete and I could get this subcontract. A subcontractor or a prospective subcontractor does not have a right to protest. It has to be a potential offeror at the prime level. And so this also comes up into play if it's a small business set-aside and you are doing a teaming arrangement or a reseller, or you're working with a reseller and you're a large business. Again, you have to worry about the issues Anna raised about limitation on subcontracting and things, but assuming you're complying with all that, if you're the large business and you think there's an issue there, you need to make sure the small business that you're teaming with wants to protest, because if they don't, you're not going to be able to as the large business. So what do you have to show? If you're an actual offeror, this is where I was getting to, the reasonable chance of award if the protest succeeds. Now, there's a lot of wiggle room here, and you don't have to show absolute certainty that you would be selected. You just sort of have to show that there's a reasonable chance. But if they're able to, at GAO, to sort of figure out that there's no way, even if all your arguments are granted, that you're going to win, for instance, if you were found technically unacceptable and you're trying to challenge something else about the awardee, but you're not addressing why you're technically unacceptable, they're going to say, doesn't matter, you're not acceptable, you're not going to get the award. So that is one sort of issue that you have to address. And you can, if you're a prospective offeror, still protest. And an example would be a large business that's protesting whether a contract or a solicitation is being set aside appropriately for small business. You may think that the rule of two has not been met, that there's not enough small business competition, and it shouldn't be set aside. Now, as the solicitation is drafted, you would not be able to put in a proposal as a large business, but you can protest ahead of time before the solicitation closes and say, you should have this as an unrestricted procurement. So that's one where you wouldn't be able to submit an offer as drafted, but if you win the protest and you're right that it should be unrestricted, you would be able to, and therefore you have an interest. Some considerations. Timeliness is very, very important in bid protests. We'll get to that a little bit in the pointers and pitfalls. Solicitation defect challenges are also very important in terms of timeliness. If there's an issue with a solicitation itself, you need to file it before the closing date for receipt of proposals. If it's in the initial solicitation, it's due by the first closing date. If it's an amendment, you have to file it before the closing date for that amendment. So those are very tight deadlines, but you can't just sort of keep a solicitation issue in your back pocket and raise it down the line if you don't win the award. You have to raise it up front. And those are really what I consider ground rules challenges. It's a challenge that you know about or you have an issue with before you even know what the results are going to be. You just think there's a problem with the process. Those have to be raised before the solicitation closes. Other protest challenges are generally at GAO. There's a 10-day standard, 10 days after you knew or should have known, and those are typically your post-award protests. Once you've been told you're not selected and you're given a debriefing and you learn about how you were evaluated, you have 10 days to file. At the Court of Federal Claims, there is no set deadline, but you have to file within a reasonable amount of time. So if you sort of snooze, you lose kind of a process. If you let things go too long and you don't file at the court, they can throw you out and say you just waited too long. So things you can protest solicitation terms. If you're excluded from the competitive range, you can file a protest there. That's typically a pre-award one because they're still making the evaluation and award decision of the folks who are in the competitive range. If it's an evaluation or award decision, you can protest that after the award has been made or announced. You can protest GSA schedule orders or buys. Those are considered federal supply schedule procurements. Those are protestable. And generally, though, there's a distinction between those and what's called a multiple award, indefinite delivery, indefinite quantity IDIQ contract. Those, sometimes we call them sort of the hunting license or fishing license type contracts where there's 4 or 5 contractors who are competing for task orders or delivery orders. And they're under an existing contract vehicle that's not part of the GSA schedule. It's just its own standalone multiple award contract. Those have to be above a certain dollar threshold, $10 million, to be able, well, actually for civilians now it's $10 million. For DOD it's now $25 million. for you to be able to file a protest of the award decision. But you can file protests if you think that that task order or delivery order, even if it's less than that threshold, if it's outside the scope of the contract. So again, if they're doing an out-of-scope task order or delivery order or award, typically you're somebody who does not have a contract and you're protesting that, hey, this should be competed broadly. I should be able to compete. Instead, you're limiting it to these 5 contractors in some multiple award situations. So those you can challenge. In terms of solicitation defect grounds, these are some of the common ones. You know, the RFP is not detailed enough. I don't have enough information to know how to do a proposal. Sometimes it's too detailed, it's too restrictive, it's too prescriptive. You have to do things in a certain way or use a certain product. That's where the brand name or equal issues come up. You know, if they're saying you have to use this brand name product, or if they're saying you can use an equal product, but they're not describing the salient characteristics in a way that lets you know what's equal. If you need more time to respond, if they give you a solicitation that requires a lot of effort and they tell you you have 3 days to respond, then that's something you have to challenge as a solicitation defect. If there's an ambiguity that's obvious, you can tell looking at it, you know, this term could mean a couple of different things, and that's, you know, really significant in terms of how I do my proposal. That's called a patent ambiguity. That you have to raise ahead of time. We'll talk about latent ambiguities are ones where you didn't see any ambiguity at the time. You find out later that the agency read it a different way, so there's an ambiguity after the fact that you become aware of. Those you can wait on. But if it's one that you know at the outset, hey, this could mean a couple of different things, I need some clarification, that's a pre-award issue, pre-solicitation issue. Small business issues typically, what set-asides, whether it's properly set aside, those are pre-solicitation issues. And then if it's a sole source RFP or synopsis, they're intending that they're going to make a sole source award, that's one that you know you got to challenge that at that stage. You can't wait until after they've made the award or sit on it, and if you know ahead of time they're going to do that. Ones that aren't solicitation defect grounds tend to be your evaluation and award issues, that they didn't follow the evaluation criteria, they evaluated you improperly or erroneously. Discussions issues, if you didn't think they gave you meaningful discussions. If you don't think the best value determination was proper, that you were lower priced, maybe lower rated, but your price difference was significant enough you should have won, or vice versa, you were higher rated and higher priced and they should have valued you because the solicitation said price is less important. Unequal treatment and then latent ambiguities, as I mentioned. So let's talk about some of the don'ts. And you know, I guess sort of hearkening back to the movie Spinal Tap, I picked 11 things, so we'll have 11 don'ts and 11 do's rather than 10. So you're getting the extra, we're going 110% for you here. So the first way of losing a protest is you're stuck with what you wrote in your proposal. And if you write a bad proposal, it's very hard, as much as I try, to fix that. And so a lot of times this is sort of an incumbent issue where the incumbent knows the work and they think they know it better than the agency. And I've had this issue come up, had a client get dinged in the evaluation because they didn't mention some particular task under their response under some performance work statement paragraph, and they said, well, everybody knows that we don't do it under that subparagraph, we do it under this other subparagraph, and that's where we mentioned it. Well, that's not what the RFP said. And you know, it's hard to challenge a ding if the RFP said address this issue under this subparagraph, and they decided that they knew better and they were going to address it somewhere else. So trying to outsmart the agency or give them what you think they should have asked for instead of what they have asked for is a really bad idea, and it's a surefire way to have GAO or the court look at it and say, well, look, you didn't follow instructions, so I'm not going to bail you out. Using the kitchen sink approach. Sometimes going into a protest, you don't really know what the key issues are. You know that there's a lot of potential issues. You're trying to come up with as many potential arguments as you can, and so you throw out the kitchen sink approach and attack everything. We generally try to be more selective than that, but sometimes you don't have enough information. You just kind of got to throw things at the wall and hope you get to the agency report level, see behind the curtain, and then you can be a little bit more selective. But the key thing is you got to start being selective, because GAO, when they see this kitchen sink approach, it sort of loses credibility with them. If you're arguing about everything, then if you have a couple of key arguments that have merit, it gets kind of lost in the noise. So it's important to try to narrow it down to really issues that you think you have traction on. Relying on conspiracy theories. I mean, there have been times where we've had situations where it looks like the contracting officer is out to get you. I've had examples of where we had email records which showed that the contracting officer lied to the client, and we submitted those. But yet GAO will bend over backwards, and the court too, to avoid finding that the government committed bad faith or acted inappropriately. And so, it's better to focus on what they did and to show that what they did doesn't make sense. You don't have to provide a motive here. It's not Matlock or whatever. You just sort of say they did something that doesn't make sense, it doesn't match up with the record, and let GAO draw its own conclusions. But when you start attacking the agency, number one, it's a way to burn bridges with your potential customer, but it's a very, very hard road to go. So that's not a good thing. Can't wait too long to protest at GAO. It's game over if you do. You still can potentially go to the court, but that's more expensive and more involved. With supplemental protest as well, there's this 10-day rule. So once you get the agency report, if there's new information in it that you didn't know about beforehand, you want to protest, you have 10 days to do it. So you got to really be attentive to the timeliness deadlines, particularly at GAO. Now, another issue in terms of timeliness at GAO is what's called pursuing issues on a piecemeal basis. And that's when you had enough information to raise an issue at the front end, you don't really raise it at the front end, the agency comes in and responds, and then you sort of, oh, and another thing. And when you do the oh, and another thing, GAO says, well, that's another thing. Is it filed within 10 days of when you knew or should have known? You knew about it 2 months ago, so no, I'm not going to consider it. So you have to be attentive to that. And if you know an issue at the time you're filing your initial protest, you got to make sure you get it in there. You got to be specific as you can. Don't be vague or speculative. I think these guys must have been unacceptable because the price is so low. That's probably not going to get you there. You want to be a little bit more specific, particularly if there's not a price realism. If the fixed price procurement, then that's usually a low price is hard to challenge unless there's a specific provision in the solicitation that says they can look at that. Again, you want to focus on matters that show competitive prejudice to win your protest. You have to show that if the outcome might have been different or very likely could have been different if the protest issue is not there. So don't focus on errors that don't matter. Focus on the ones that do. And another area that it's very hard to get traction with is when it's a very technical issue. And GAO and the court, they're not experts in this particular technical field, and they're going to rely on the agency who's buying this service or this good to say, the agency knows better than I do whether what you wrote in this proposal about how you're going to do this and that with these widgets makes sense or not. They're not going to want to second guess it. Now, what you want to be able to show, where you can get traction with GAO particularly, is showing some concrete issue there. You're not second guessing their judgment so much as you're saying they said they'd evaluate, these are the evaluation criteria, and they pulled something that's completely contrary to the evaluation criteria, or they injected some new criteria here, and that's why they dinged me. That GAO will be responsive to if you're showing that it doesn't follow the evaluation criteria. Or if you show that they said that this was a strength of the awardee, and you have the same thing, and they didn't give you a strength, or they dinged you for a weakness that's also present in the awardee. So the unequal treatment aspect GAO can understand. But if you're asking them to say, I should have gotten better rated on this, this should have been seen as a strength, and it's a very subjective issue, that's going to be hard. Again, you're not going to get anywhere in the post-award protest by saying that the price evaluation methodology in the solicitation was wrong or bad or should have looked at something that it didn't. Those are sort of pre-solicitation issues, and so you have to work with what the rules were in the solicitation as it closed and not try to challenge things at that stage. As I mentioned earlier, you can't just sit on a solicitation issue until the award decision and then try to pull it out if you don't win. So, for instance, let's say there is a price evaluation issue. You're looking at the way they describe they're going to evaluate price, and you think this doesn't really accurately measure their costs. They've got some bad estimates here, or they're applying these in a way that's going to somehow let somebody game the system. If you think that's a problem, you need to raise it at the solicitation phase, and then you can't sit on it and then when the award is made, say the awardee gamed the system. They did these things they shouldn't have done. If that's what the evaluation scheme said, those are the rules. And another pointer here is you can file at GAO, you can file a pro se protest, you can file as a company in your own name with a corporate rep without a lawyer, but it's really limiting if you're going to try to file a protest about anything other than some specific aspect of your proposal or your evaluation, because as outside counsel, if you hire an outside attorney, you are able to get admitted to a protective order, and so you are able to see the evaluation materials and other guys' proposals, and you can have a bigger picture to raise new issues. If you're going in on your own because of competitive reasons, they won't let you see those kind of things. You can't see what your competitors put in as their proposal, so you get things that are very redacted unless it's directly addressing your proposal. So it really limits you. I mean, you can do it. People have done it. And sometimes they're successful if it's a flagrant violation of what they did with your proposal. But if you really want the fuller picture, it's better to have an attorney there. So in terms of things to do as opposed to not to do, it's really important to seek legal advice about potential protest issues sooner rather than later. And I would say the minute you think you might have an issue, you should reach out. And, you know, we encourage people to reach out to us at an early stage because obviously we're the ones who have to scramble at the last minute if we're trying to put a protest together under the gun. And typically we will have discussions, myself, David Ralston, and other folks with clients and sort of try to suss out whether there are some issues, whether there are specific things you should ask about in a debriefing, whether there's issues with the solicitation they should raise in a pre-solicitation protest. And we do that without billing time at the front end and sort of seeing if you've got an issue. And then if it looks like you're going to have a protest issue, that's when we start talking about, okay, you know, here's what the representation will be like. So because these deadlines are so strict and unforgiving, you should try to get legal advice brought in, whether it's in-house, outside counsel, whatever. Try to get a read on the protest issue sooner rather than later. And the worst thing is when somebody comes and says, you know, I thought this might have been an issue, but they didn't raise it, and now it's too late. In terms of trying to make that distinction between what's a solicitation defect issue and what's just sort of an other issue that I can wait on, the rule I try to tell people is if you think there's something wrong about the competition before you even know the outcome, it's generally that means that there's a concern about the ground rules. There's something about the evaluation scheme you don't like. There's specifications that you think are too restrictive. Those are pre-solicitation issues, solicitation defect issues that you have to raise before the proposals are due. And we've already discussed on one of the other slides some of these common issues. But so if you see those issues, even before you know who wins, you think there's an issue, raise that at the solicitation closing phase so you can be timely. Again, this is a little bit repeating, not trying to outsmart the agency, but it's also sort of being responsive to what they've asked you to give them. They've got a section L that tells you what your proposal should include, what the format is, and the typical RFP. There's a section M that tells you what the evaluation factors are, what the weighting is supposed to be in terms of price and non-price factors. And so, you know, be very attentive to what they're asking you and formatting requirements and everything else, because it really is tough when there's a page limit issue and you're, you know, at the last minute you're formatting it and you go a couple pages over. I mean, it's hard to deal with that because GAO says you didn't follow instructions. So it's both on the formatting side and on the content side. Read and let them tell you what they want and then give them what they're asking for. You can use an agency-level protest. An agency-level protest is when you go to the contracting officer themselves directly as opposed to going to GAO or the court. And I think those can be very useful in a solicitation defect issue. There's no awardee that's been selected yet. The contracting officer is trying to do a good procurement, and they're trying to do one that's not going to get protested or it's going to give them the best value. And if you can explain to them, you know, look, here's an issue, dealt with this with a client a couple months ago where there was a RFP that had some restrictive requirements. It seemed that they were written around a competitor's product that would eliminate their ability to compete. And so you raise those issues. Here are the ones we're concerned about. We don't think these are necessary. Other agencies have used our product without issue. And you sort of have that dialogue. You do it in an agency-level protest before going to GAO right away. And in that case, the contracting officer listened and they changed it and they broadened the requirement so that the client could compete. And that's one where you can get that result in the pre-award, pre-solicitation phase, I think, more often. Once the award's been made, it's tougher because then somebody's actually said, this company wins, and they're invested in that decision, and now you're asking them to sort of second-guess that decision. It's harder, and so we think that the agency-level protest is better in the solicitation defect issue than an award issue typically. Another thing you can do sometimes, particularly with the solicitation defects, is you've got a very short timeline sometimes. There's a new error that comes out in an amendment to the solicitation with a very short fuse. If you send a letter in to the contracting officer raising the agency-level protest, you can get your foot in the door to at least preserve that issue to then go to GAO 10 days later if they don't act on it. But you don't have to have a full spun-up GAO protest within a couple of days. You give yourself a little bit more time. When you are eliminated from a competitive range in a negotiated procurement, sometimes they have a competitive range where they narrow down the number of offers to a smaller subset that they're going to negotiate with. And so sometimes you're told you're not in the competitive range, thanks, you can have a debriefing now or you can have it after the award. And if you ask for it after the award, you'll get more information because right now we can't tell you much about anybody else. So sometimes there's a temptation to say, I'd rather wait for the more information later. But that's really, I think, strategically a bad idea if you think there's any chance of you getting back into the competitive range. It's better to ask for a debriefing at that stage to try to figure out if you have a protest issue at that stage, because it's easier to get the agency to take corrective action if you file a protest and point out some issues. The issue is, well, should I have a sixth firm in the competitive range as opposed to 5 and still have to fight this protest? Or, do they have some merit to this argument and I might keep them in? If you can get yourself back in the competitive range, you have a much better chance of having a successful competition for the contract than if you wait till somebody else has been selected and try to get the clock turned back to the competitive range phase. You should always ask for a debriefing in writing. You should sort of ingrain in yourself that when you typically now you get these notice of awards by email, here's this letter telling you thanks for your participation, but we went with somebody else. Hit reply and say, I'm requesting a written debriefing or I'm requesting a post-award debriefing. And you have to do that within 3 days, 3 calendar days. So again, a lot of these notices somehow miraculously seem to come in on Friday afternoon. Those weekend days are counting against you for a debriefing. So it's almost like, treat it like an out-of-office notification that it's sort of, boom, you're sending it right back. I want a debriefing. Now, debriefings are not required in every case. If it's a GSA schedule order and it's an RFQ under the GSA schedule, typically they're not required to give you a debriefing, but there usually is a provision in the solicitation that they'll give you some information, and that information is better than nothing, and you can at least get it. The issue about required or non-required debriefings factors into the stay of performance issue, but you still have a right to file a protest after a debriefing if you learn something new in it. Whether it's a required debriefing or not, it's certainly a better opportunity to get it. And if you want to make it a required debriefing, you have to file your request within 3 days. So there's really no reason to wait on that. Again, if you're going to do a debriefing, particularly if it's one that would be required because you've requested it on time, and it's a competitive procurement, negotiated proposal procurement, the timing for the stay of performance or the stay of the award is that you do it within 5 days of the first date that they've offered. So usually, if they come in and say, can you do it on Tuesday, and Tuesday's a really bad day for you, if you come back and say, no, Tuesday doesn't work, theoretically your clock for the 5 days, for this automatic stay start counting from that Tuesday. So you should really do whatever you can to make sure you can do a debriefing, even if it has to be over the phone or if it's just they're going to send you written materials in the email. Do it by the first date if you absolutely can. Knowing the rules about the stay of performance are important. Again, it's 10 days after a contract award or 5 days after an automatic or after a required debriefing if that's later than the 10 days after award. So knowing those dates as far as the automatic stay at GAO are really important because a lot of what you do when you're filing a post-award protest is geared towards trying to get that stay. And, sometimes you'd file a protest sooner than you absolutely have to. You could be timely at GAO for protest purposes, but out of time for the stay of performance. So you want to make sure that you're complying with those requirements. If you're the awardee, a lot of times your thought is, well, protest, that's the agency's job, they're going to defend me. But we recommend at GAO and at the Court of Federal Claims, you can intervene as the awardee and sort of help defend the protest with the government. And, there are varying degrees of competence by government agencies and by government counsel in terms of how well they'll defend an award. And the other thing, too, is if you don't intervene as the awardee, it can sometimes signal to the government that you're not really as invested in the process, that they're not going to have to answer to you if they decide to take corrective action. Hey, if I agree to reevaluate proposals and make a new award decision, this protest will go away, this other guy will be happy, and the awardee hasn't said anything, so, I win. If you're in there saying, I'm here, I'm participating in the protest, they know if they take corrective action, you're probably not going to be happy. Now, maybe that's still not enough to dissuade them, but at least signals that you're concerned. And you also have a chance sometimes in terms of the briefing and everything else. If the agency's not doing a great job or is missing the ball on some things, you can sometimes help out and help fill in the gaps. So rule number 10, if you're as old as I am, you remember when Atari was the cutting edge on video games. There's the video game Pitfall where you had to sort of try to jump over quicksand and the alligators and things like that. And so got a little cartoon here. GAO, they have such a busy docket that they are, they'll probably hate me saying this, but they are looking for ways to resolve protests quickly because they've got so many they've got to do within 100 days. If they can find a trapdoor to flush your protest, they will use it. And so know where they are. Timeliness is a big issue. The interested parties issues are big. If they have a way to dismiss your protest, they will. So know where the trapdoors are, and then you can, avoid those. And then Rule 11 is sort of, we've got the detailed articles on the protest procedures and processes. Those are a good resource. If you read those and become familiar with them, even when you don't have a protest issue immediately on you, you become a little bit more familiar and a little bit more comfortable with how to handle it. So, now I have to make the announcement for the folks that are online about the CLE information. I'm going to read the CLE code for the program. If you are online and need CLE credit today, please enter this 5-character code into the poll question on the screen after it is announced and press the Submit button. The code is X as in X-ray, G as in golf, V as in victory, G as in golf, S as in Sierra. And I'll repeat that a couple more times. It's X as in X-ray, G as in golf, V as in victory, G as in golf, S as in Sierra. X as in X-ray, G for golf, V for victory or for vendetta, depending on how you're feeling, G for golf, and S for Sierra. So again, if you are seeking CLE credit this session, please complete the polling question by entering that code, and you should be good to go. So I'll close quickly with this success story that I mentioned, a company called Inframap that does underground utility locating. So when you call Miss Utility and somebody comes out to mark where the gas lines and the water lines are, that's their field of business. And so that, whenever the federal government is doing some construction work on a federal facility, they need to have those utility location services, and they were competing the utility locating services for Aberdeen Proving Ground, where Inframap was the incumbent. And so the issue here was that essentially they were going to ask for a fixed monthly price. So any amount of utility locating I need for a particular month, you're going to charge me, whatever, $10,000, and you're going to have to do it. And so there was an estimate in the RFP about based on historical usage and everything else, here's how much we think we'll need. And so that was what people were told to base their bids on. And again, it was the lowest price technically acceptable award. So again, low price is going to be very important here. It's going to be determinative of who wins. And so the RFP was projecting that the underground utility locating requirements would increase by 10% over the prior year requirements. And so that was sort of what everybody was told to estimate their pricing on. And so then they issued an amendment saying final proposals are due in 4 days. And on that same day, the chief engineer on the base came in and was talking to the Informap person on the base and said, oh, by the way, we're privatizing all our utilities here on the base in a couple of years, and all of that work is going to be covered by this fixed price. And that was orders of magnitude more utility locating than was projected by this estimate. And so, you know, the Army's position was, hey, you know, what's the problem? You know, we said this is a requirements contract essentially where you're going to give us a fixed annual rate to do this work no matter how much we need. We've estimated an annual increase that's based on the number of permits, not on the mileage, which is really what determines how expensive it is. And so, you know, we're covered. But Informap was concerned because they had really two options here, and this is something that I've seen other clients have. When you have a solicitation that gives you some bad options, you know, they picked a third choice, and I think it worked out for them here. But one option was you go ahead and you say, close your eyes to what you just heard and say, I'm going to bid based on what they're telling me. I'm going to give a low price to try to win the award. But then I know I'm going to get socked with this huge amount of work. They're going to say, you knew that going in, and we're not going to give you a mod or an additional request for equitable adjustment. You knew what you were buying when you gave us this price. So that's not a good outcome because that's a money loser for them even if they win the contract. If they bid on what they think the real estimate is, nobody else out there who's competing with them knows about it, and so everybody else is going to come in at one level. They're going to be way up here, and they're never going to win. So it seemed like a lose-lose. But what they decided to do was be proactive, and they filed a protest at GAO that said, look, the RFP does not accurately reflect the estimated workload, and so we're not able to compete on an intelligent basis with everyone else because everyone else thinks the workload's down here, and we know it's going to be up here, and that's not fair. And so the Army said, oh, well, forget about it. You know, the workload projections were in the original RFP that was closed months ago. This is, you know, a fourth or fifth round of amendments where we're asking for best and final proposals, and that workload projection hasn't changed. So remembering my, you know, if you have a solicitation defect issue, you have to file it before the closing date for proposals the first time, or if it's an amendment, something later. And so they tried to say this was untimely, and we pointed out, no, it's not, because when you gave us that initial workload, we had no reason to question it. It seemed reasonable, it was right. The only thing that told Informap they needed to question that estimate and the adequacy of it was that meeting in the office that happened a couple of days earlier. So they were within 10 days of that issue, and they were timely, and GAO agreed. So the moral of the story is that, you know, Informap raised this issue. GAO agreed that they, you know, when we got behind the curtain to see what kind of analysis has the Army done, because the Army said, hey, look, you know, this utilities privatization is still consistent with what we'd said in the original estimate. And so GAO said, well, where's your analysis that shows that? And they had none. And so it really showed that they didn't do the analysis, and GAO said, given that, you need to go back and figure out if your estimate is really accurate or not. And if it's not accurate, you need to update it so everybody's competing on the same ground. And so when they took that corrective action and they revised the proposal and everything else, Informap bid, and they were the lowest price and the technically acceptable, and they won. So, you know, they were faced with bad outcomes, but they took a proactive approach, and I do think one of the morals of the story is that taking an appropriate pre-award protest when you see a solicitation issue can be just as good, if not better than a post-award situation to try to put you in a position to win. So that is the end of my presentation. I'll turn it back over to Aaron.